system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice.
Court this morning, along with his counsel. Counsel, please state your name for the record.
Walt Edwards on behalf of Mr. Halasz.
On behalf of the state of Ohio, would you please state your name for the record?
Gregory Paul, Assistant Prosecuting Attorney, Your Honor.
Thank you very much. Previously, on October 21st, 2024, the defendant pled guilty to count 1, attempted murder. That is a felony of the first degree in violation of 2923.02 and 2903.02a. That carries a possible penalty from 3 years in prison up to 11 years in prison and a fine of up to $20,000. This charge is also subject to Reagan-Tokes, which means that once the defendant is placed in once he is sentenced, he's looking at an additional, could be up to an additional 5.5 years. So on this charge, he's looking at anywhere from 3 years in prison up to 16.5 years in prison. The court has had the opportunity to review the pre-sentence investigation report that was prepared by the Cuyahoga County Adult Probation Department and has made that report available to counsel. Before imposing sentence, this court will consider the record, the PSI, and any written or oral statements made to the court today as is required by Revised Code Section 2929.19b1. Mr. Halasz, we are here to impose sentence in your case. Before I determine what sentence to impose, I will allow you, your attorney, as well as the state of Ohio to address this court. Before we get started, counselor, is there any reason to not go forth?
No, Your Honor.
Then you may proceed first, and I'd like you to come to the podium when you speak. Thank you.
Thank you, Judge. Obviously, this is a horrible situation. You have a clinician, someone who has dedicated their lives to trying to help people. He's a healthcare provider. He had seen my client, I think, for the better part of 2 years, who was being treated for schizoaffective disorder and a host of other mental illnesses. And on the date in question, he had been treating my client, and Mr. Halasz had taken some issue with the manner in which he was treated, and I think at the time was experiencing sort of irrational thoughts that this gentleman was not out there to help him, when in reality he certainly was there to help him. And the factual basis for the charges themselves are that he took a knife out of his sock and he struck this individual 7 times, including but not limited to at his neck. It is a horrible, horrible thing that happened to someone who, again, has dedicated their lives to helping people who were in need. So then he was charged with attempted murder, and the logical thing for someone who has a history of mental illness is to refer him for competency. And so he was referred to the court psychiatric clinic for competency. And I sort of knew at that time, just based on my interactions with him, that it's very likely that he was competent. He understood the role of the court, he understood the role of the prosecutor, defense counsel, had present ability to assist counsel. But that was the first step, and it was important because what it did reveal is a significant history of mental illness. He was first diagnosed with schizophrenia, schizoaffective disorder when he was 18. The report details 3 subsequent hospitalizations. And it was for sort of irrational and delusional thinking. And it was not something that he had necessarily, or it's at least not borne out in the record, something that he had experienced in adolescence. What it did show that he experienced in adolescence was a good bit of tumult in his family. He was not raised by his mother and father for the most part. He was raised in his grandfather's home. The report details that he was kicked out when he was 18, and this is sort of the inception of the symptoms that he was starting to experience as a result of his schizophrenia. And he did have family support, and he's got a great deal of support here with him today, but it didn't lessen the impact of the symptoms on how he was navigating through life. That said, he managed to not hurt anybody. He didn't have a criminal history. He's only 24 years old. He's a baby, and he didn't harm anybody else. He doesn't have, at least in my estimation, a predaceous bone in his body. He didn't try and steal anything from anyone. He acted or was compelled as a product of his mental condition, right? So what I would submit to the court is that he is what I would term as a sort of gap situation. So it is something that the legislature and the Supreme Court and this court and DRC, no one has really contemplated, because he is someone who's competent. We had him then referred for not guilty by reason of insanity, and the clinician said, essentially, and I paraphrase, that while he was sort of driven by these mental health problems, he had a rational basis for what he had done, which is that he did not like the treatment that he was receiving by the clinician. And there was some degree of planning involved, and there was the secreting away of the instrumentality of the crime itself, which would suggest an awareness that he shouldn't have done what he was supposed to do. So we knew, and we didn't purposely seek a second opinion on NGRI, because we're not playing games here. We know that that is not, or at least in the estimation of this clinician and others that I've consulted, there's a colorable basis for it. We knew that. But so he's competent, he's not NGRI, but he is nevertheless compelled by the demons in his head, by the mental health issues, by his schizoaffective disorder. And there's not a statute that recognizes that. Ohio doesn't recognize diminished capacity. There's nothing there, right? And it's a problem. Ideally, we would live in a world where you had greater resources to put someone in a secure setting beyond necessarily a CDCF, a lockdown facility where someone has the potential for a longer stay than 6 months, but you don't have it because the legislature and the Supreme Court haven't given it to you. So what we're left with is either a period of incarceration where he's going to be at the DRC with woefully inadequate treatment, or the supervision of the court. And I know it's a bold move asking you for supervision on an F1 attempted murder, but I'm asking for it. This shouldn't have been an attempted murder. The government failed to amend this or refused to amend this, and I understand their position. But they did so out of fear for your compassion in how you sentence progressively. That's why they didn't do it. There was no amendment, no consideration that was given to a 24-year-old young man with no criminal history, where all of us can agree that he was acting out of mental illness. Not 1 ounce of consideration. Nothing. And they did that because they fear you. They fear your compassion, and that you would get this. You would get that putting him in a cage with at the Department of Rehabilitation and Corrections with inadequate mental health counseling is not going to serve anybody, because not only are they not going to be able to treat him, but guess who's going to be able to guide and treat him who has even less resources? The APA. So we're going to put him in a cage where he's going to have an uneven medication schedule, and then when we release him from that cage into the community, we're going to have him supervised by the Adult Parole Authority, who has even less resources than the DRC. And who's going to be better off then? The people in the community that he's released to? No way. There's not a chance. Or, in the alternative, the court is in receipt of Lottie Gray's plan, who I appreciate all of her efforts. She puts together what I think is a very logical plan that starts with 6 months of lockdown, treatment, incarceration, followed by whatever the court is inclined to order as far as continued programming that he's supposed to be engaged in, GPS, home detention. He can go back into another facility if the court in the probation department, Ms. Gray, finds another one that would be appropriate as well. But the point is, you could conceivably supervise him infinite, right? So the statute says that you can only supervise someone for 5 years. Well, we know as a practical matter that there are people who have been under the supervision of the court for far in excess of 5 years. It gets extended, and there's not a statute that contemplates that says that you lack the authority to extend it beyond 5 years if there is a finding that it's appropriate, right? So you just can't order 5 years on the front end, but you can always extend it. So who is going to be better off when this court, who has all the resources, is going to be able to supervise him functionally, potentially, for the balance of his life, or we're going to put him in a cage. And then when he's done being in that cage, we're going to have him supervised by a non-mental health trained adult parole authority parole officer who has access to limited resources, who's going to dump him in a community and say, here, I hope the best for you. I think that the option with respect to supervision is far more logical. I think that contemplates the safety of the community best. There's no way that sending him to prison and then releasing him is going to ensure the safety of the community. If we have to met out some sort of punishment for this mentally ill young man, he's going to get locked up for a minimum of 6 months at a community-based correctional facility. He gets it. He regrets it. He didn't want to do it that day. He understands that this individual didn't deserve that. The government's going to show you videos and pictures of injuries which are very, very compelling. There is no doubt this should not have happened. This man did not deserve this. But if you want to fashion a disposition most consistent with the purposes and principles of felony sentencing, what I have proposed and what Ms. Gray has proposed, I believe, is most consistent. And I would thank the court.
Thank you very much. On behalf of the state of Ohio.
Thank you, Your Honor.
You and your client can have a seat.
Thank you.
Yeah. Judge, you had, and I had a chance to review today the pre-sentence investigation in this case, and I'll not regurgitate the basic facts as I know them to exist, as they are quite adequately explained in the PSI itself. The named victim in this complaint, Adam Brown, was a psychiatrist for the defendant for at least 2.5 years. There were never any physical altercations or any physical incidents that occurred between these two prior to April the 24th, 2024, when, as an employee at Signature Health, Adam Brown was viciously and premeditatedly attacked by this defendant. Judge, we had provided, and I hope the court had received and had an opportunity to review, Mr. Brown's 3-page statement where he provides this court in great detail, not only the physical injuries that he suffered, but the psychiatric and emotional trauma this incident had and continues to have on his and his family's life. Your Honor, I would like to present to the court surveillance videos that exist of this event, at least in some form. Thereafter, Your Honor, I would present the court some pictures of the actual injuries suffered by Mr. Brown. But first, I had offered Mr. Brown the opportunity before playing these videos that he has not seen, the opportunity to step out of the court before I play them for the court. So,
Did he want to be heard today?
He does wish to be heard, and all I'm going to do, Judge, is ask him to step out, and then when I'm completed showing you these 90-second videos, he's going to come back in.
All right. In addition to the victim, are there other people going to speak as well?
At this point, Judge,
Any other witnesses?
just the victim.
Okay. All right.
Judge, I marked these two surveillance videos as State's Exhibit 15 and State's Exhibit 16. And I hope the court can see adequately here. All right, just to set the, give some context to the court. Your Honor, this is surveillance video the moment the actual attack occurred inside what was Mr. Brown's office. You see him run out clutching the right side of his neck, and you see the defendant follow after him. There'll be a second view that shows in more detail what occurs after that, but needless to say, this was, I'll start again at the 0-second mark. In total, it's 1 minute and 32 seconds, but you'll see, you don't see the initial attack, Judge, but you do see Mr. Brown fleeing from his office, and he's being chased, if you will, eventually by the defendant. And I'll just play this in narration and not narrate it further at this point, Judge. And I'll stop at the 1 minute and 5 second mark, which is the point, Judge, when security from the first floor arrives at the second floor. This next view of surveillance video is marked as State's Exhibit 16. It offers the court a view of, I guess, where Mr. Brown ended up on that second floor. As you saw him run down the hallway and make a right, this will give you that view of that hallway. One moment, Judge. And once more, this is State's Exhibit 16, which is that other hallway on the second floor of Signature Health. And you'll see Mr. Brown and eventually the defendant enter the screen here in just a short while. And now you see Mr. Brown enter once more, still grasping the right side of his neck. And that's the defendant carrying on with his attack. Where, of course, he's subdued momentarily by a staffer. Only to continue attacking Mr. Brown. Until eventually security does arrive from the first floor, Judge, and orders the defendant down to the ground at gunpoint. Your Honor, the injury suffered by Mr. Brown, he can explain obviously quite a lot better than I could. But for the good of the record, Your Honor, I would like to offer the court several exhibits that we've marked as State's Exhibit 1 through 10. These have previously been provided to counsel in discovery, and specifically it's provided to Mr. Edwards yesterday. If I might approach the bench, Judge. These are State's Exhibit 1 through 10. They were taken, I think, several days after at Metro Health where Mr. Brown was receiving care. Obviously, you see the large gash on the right side of his neck. That was the severing wound that severed his jugular vein. He also suffered various other wounds to his trachea, his midsection. He had several defensive wounds that are visible in States Exhibit 1 through 10 on his hands. Lastly, Your Honor, I would like to provide to the court, and again, these have been previously provided to counsel, generally discovered specifically yesterday as exhibits that we would show the court today. These are States Exhibits 11 through 14, if I may approach once more.
Yes. I'm sorry, what's the difference you said?
Difference is
Oh, I'm just,
1 through 10 are various injuries about the body.
and what'd you say this was?
Those are specific crime scene photos.
Oh,
where he
gotcha.
lay, as well as the knife that Mr. Edwards alluded to that was secreted away by this defendant before he arrived at Signature Health that day.
This was, looks like a knife that's covered in what, like tape or something? Or is it a real knife, or is it more of a something else?
It is a knife. I can surmise just from looking at it that it was covered with tape, and I'm recalling from the defendant's own statement in his sanity evaluation that he had taped the handle of the knife for whatever reason.
Okay.
Also in that statement, he did discuss his efforts to purposely secret that away on his body. I think he said he tucked it in 2 layers of socks in his boot before he arrived at Signature Health that day for his scheduled meeting with his clinician, Mr. Brown. Mr. Edwards alluded to the fact that we weren't inclined or did not offer any sort of plea to this defendant. That is true. Because in every sense of the word, every definition of the word, or words that make up the offense of attempted murder, this defendant did. He purposely sought out to kill that day Mr. Brown. And by no design of his own, Mr. Brown is still with us. The only reason Mr. Brown is still with us today is because of the efforts made by Mr. Brown's co-workers who saved him from this attack. Because security, by my estimation, was about 90 seconds too late in helping Mr. Brown. They had to throw 2 chairs at this defendant, had to physically grapple with him to keep him from furthering his attack on Mr. Brown. It was only until Mr. Halasz was ordered down at gunpoint that he ceased. Your Honor, what is depicted in the video is an unrelenting, premeditated attack. It's cold, it's calculating, it's almost indescribable to put into words. Thankfully, we have it here with us today so this court can see exactly what this defendant did to a person whose only purpose that day was to help him. Yet he carried about a plan to murder a person that only exists to help him. His sanity evaluation, he discussed in great detail that he was not satisfied with the care that he was receiving from Signature Health and Mr. Brown, and he wanted to put into motion a certain event to eliminate that. I had a conversation with several persons, including Mr. Brown today, that our system isn't really set up to find out why a person commits a crime. We're just not set up for that. We may go through an entire trial and we'll never know why a defendant does a certain act. That's known only to him or her, and such is the case here. It's personal to Mr. Halasz why he decided to attack Mr. Brown this day. Your Honor, I am not unsympathetic to the plight of persons with mental illness. We see far too many cases come through this courthouse where persons with a mental health history or a mental health diagnosis attack a police officer or assault a family member. And you know what? We do give those persons services. We're not quick to lock up anyone because we acknowledge that they do have a mental illness and the gravity of the harm, not to say it's okay to attack anyone, least of all a police officer, I'm just using that by way of example. But the actual harm caused can be repaired. It can be remedied. We can offer you services. But here a line was crossed. And that line comes with it repercussions when you cross that line. If Mr. Halasz had carried out his exact plan, we wouldn't be talking today about reintegration plans and CBCF. We would be talking about putting Mr. Halasz away for the rest of his life, because he would have murdered Mr. Brown, because that was his specific intention. At some point, Your Honor, the needs of the community, and frankly the needs of persons that are engaged in mental health services have to be put before any notion of sympathy or services for defendants, even if they have mental health illnesses. Mr. Edwards, unfortunately, takes a very dim view of the services and resources offered by our DRC and our specific prisons. They are adequate for what we can offer. It's not perfect, but it's something. But again, we're not here to talk about the needs of Mr. Halasz anymore. He crossed the line. Accordingly, Your Honor, we would ask this court to impose a sentence of 11 years, which I realize is the maximum amount. And I realize that on its face, asking for an 11-year sanction, a maximum sanction in this case, might make it appear as though I'm not sympathetic to his mental health needs. I am, but the needs of the community have to come before that. Your Honor, I would like the opportunity for Mr. Brown to be heard, if he would join me at the podium. Just state this right.
My name is Adam Brown, A-D-A-M-B-R-O-W-N. I'd like to thank this court for giving me the opportunity to speak today. The events of April 24th have significantly changed my life. The defendant's actions on that day had a deep impact on me, which will affect me for the rest of my life. He left me with both physical and emotional scars that will be constant reminders of the violence that was inflicted upon me that day. First, the physical scars. I suffered from multiple stab wounds to my neck, chest, and hands. The injuries to my neck being the most significant and nearly ended my life. My right internal jugular vein was severed and had to be ligated and is no longer functioning. I had stab wounds that punctured my trachea and caused significant damage and impaired my ability to speak and swallow. The wounds on my hand were caused by me trying to protect myself from the stabbing that he inflicted upon me that day. As a result of these injuries, I suffered from major blood loss and required resuscitation before emergency surgery could be done to save my life. I was in surgery for 6 hours when I woke up. I could not speak or swallow. I had a tracheostomy so that I could breathe, and a feeding tube so that I could eat. I was in the ICU for several days. I required intensive physical and speech therapy to improve my ability to speak and swallow. This continued for several months after I was discharged. I have nerve damage that affected my ability to use my right arm and causes me pain. This will also require ongoing therapy. I have no sensation to my right ear and most of my neck, and it is unknown if this will ever return. Although these physical wounds are healing, I will have the scars from them for the rest of my life. Now for the emotional damage I see. I suffer from symptoms of PTSD, including flashback, intrusive thoughts, hypervigilance, fearfulness, guilt, anger, dissociation, and panic. I also have symptoms of depression and anxiety, such as increased worry, insomnia, sadness, lack of motivation, anhedonia, low energy, feeling overwhelmed, irritability, racing thoughts, poor focus, and concentration. These symptoms have been intrusive in my life and still affect me today. Because of this, I have had to undergo intensive trauma and EMDR therapy to try and control these symptoms. Writing this statement has caused me to have an increase in all these symptoms due to having to relive the events of that day and the trauma that I continue to have from it. I've been fearful to work from my office at Signature Health and to see patients in person. I am only able to see patients virtually from the safety and security of my home. This attack has also affected my relationship with my wife due to symptoms of PTSD that we both have. I've had less interest in doing activities that I normally enjoy, such as spending time with my friends and family, working out with my friends, and spending time with my children. I feel anxious and on edge, which causes me to have increased irritability with my wife and children. I have trouble keeping up with the household chores and activities. Loud noises cause me to feel increased anxiety and fearfulness, which I feel throughout my whole body. I have had multiple times where the PTSD symptoms could be triggered by reminders of this event. During these times, I will feel increased fearfulness, dissociation from the environment I'm in, flashbacks, intrusive thoughts, and panic. When this happens, it will take me several hours to calm myself. This has not only affected me, but it's also affected members of my family and coworkers who were there that day. My children are young and they struggle to try to process and understand what happened to their father on that day, and not knowing why Daddy was not coming home from work. Everyone in my family and friends close to me had to deal with the realization that I might not have survived that day. This has caused significant emotional stress for everyone involved, which is still healing to this day. On that day, he almost took a husband away from his wife, a father away from his children, and a brother away from his siblings, and a son away from his parents. The impact that it had on my coworkers who were there that day has also been great. They witnessed firsthand the attack on me and saw the violence of his actions. He passed several of them in the hallway with a knife in his hand as they came out of their office to respond to my screams for help. My supervisor tried to get me to safety in her office, putting her own life in danger to try to save mine. Several others tried to physically stop him as he was actively stabbing me with the knife, putting their own lives in danger. When the attack was done, several of my coworkers came to my aid as I was bleeding to death, applying pressure to my wounds and my neck to try to control the bleeding and offering support and hope that I would live despite me having already accepted death. Everyone who was there that day witnessed the horrific crime, and they were deeply affected. They all suffer from PTSD that requires them to get intensive therapy as well. Many are still struggling with the symptoms to this day. As you can see, they're all here in support of me today. Due to the nature of this crime, I feel that the defendant should get the maximum allowable sentence under law. This is based not only on the horrific nature of the attack on me and the violence of his actions, but also the significant risk that the defendant poses to others in the community at large. The attack on me that day was premeditated, unprovoked, and had the intent to end my life. I say this because he brought the knife in that day with the intention to use it to kill me. His attack on me that day was not isolated to one assault. After stabbing me in my office, he stalked me through the rest of the office floor to continue his attack on me with the intent to kill me. He did not stop his attack as I tried to flee to safety, despite having several opportunities to make an escape through 2 doors that he passed that he could have exited to leave the building. He chose instead to continue his attack with the intent to kill me. The attack on me was also unprovoked. He had no history of violent behaviors towards me, and he had no indication that he would do this to me that day. Every appointment we had prior to this day consisted of friendly conversations between the 2 of us to check in on his well-being and to treat any mental symptoms that he may find distressful for him. We had no history of confrontation. I strive to build a patient-provider relationship based on respect between us. I have both a legal and a moral obligation to provide psychiatric care in a manner that is respectful, based on trust, and will do no harm. I was not given that in return. On that day, he broke that trust. He chose to try to end my life for reasons that are unknowable to me to this day. Not only did he break that trust in our relationship, but he has made me question whether I can feel safe and trustful in relationships with the hundreds of other patients that I see. I also feel that he poses a threat to the community at large. The unprovoked nature of his attack on me shows that he is capable of doing this at any time to anyone. Although his attack was focused on me that day, it changed the lives of dozens of people. Right now, he poses a risk to everyone that he has contact with in his life, and I feel that giving him the maximum sentence that this court sees fit to give would help protect me and others. Thank you, Your Honor.
Thank you. I'm sorry for what you had to go through. And how are you doing today?
It's a rough day.
So are you back to work full-time, or are you?
I am. I started back in August. Like I said, working exclusive from the home. I did go to the office a couple times, but I had to leave early on those days because those were triggered days for me.
Okay.
An example of that was one day I was in my office and music was playing, and it was a Wednesday, and the attack happened on the Wednesday. A song came on, a song that I didn't necessarily pay any attention to, and the same music plays on Wednesdays, and I instantly went into flashbacks and had to leave.
Okay. How long were you offering him treatment?
For about 2 years.
2 years.
Maybe a little bit more.
Okay. All right. Anything else you want me to know? All right. Thank you very much. Anyone else wants to speak?
No, Your Honor. We have
Okay.
nothing further, Your Honor. Thank you.
All right. Thank you very much. You can bring your client back up, and Mr. Halasz, you have the opportunity now to speak. You have the opportunity now to speak. What would you like me to know?
Your Honor, I just want to say I'm sorry for what I did.
That's it, Judge. We would thank the court.
All right. You know, I have 2 requests here. I have one for community control and one for the max. And I can tell you that this case is very troubling to me. And when I saw the video, it was, even though I wasn't there, even though, you know, this is, 8 months later or 7 months later, I can tell you that I felt the fear of him going through the halls, stalking his victim. After consideration of the record, the oral statements made today, looking at the pre-sentence investigation report, looking at the purposes and principles of sentencing under Ohio Revised Code, Section 2929.11, the seriousness and recidivism factors relevant to the offense and offender pursuant to Revised Code, Section 2929.12, and the need for deterrence, incapacitation, rehabilitation, and restitution, the court does find that a prison term is consistent with the purposes and principles of sentencing set forth in section 2929.11 of the revised code, and finds that the offender is not amenable to an available community control sanction. Furthermore, this court has considered the factors set forth in 2929.12 and finds that a prison term is commensurate with the seriousness of the defendant's conduct, his impact on the victims, and is reasonably necessary to deter the offender in order to protect the public from future crimes, and would not place a necessary burden on government resources. This crime was, in my opinion, so horrible that even I know all of the staff has to also have PTSD from this, because of the way it occurred, and the stalking, and sort of the and the seriousness of the injuries. These injuries are extremely serious. I do not think, and as you can tell, I don't believe that community control is appropriate in this case. And I am mindful of his mental condition, that he has a schizo affect. Let me just make sure I'm saying it correctly here. I am mindful of his condition, and I have the reintegration plan that was prepared on behalf of the by the mental health jail liaison specialist, Lottie Gray, and I have reviewed this. But even with all of this, I believe that this is a serious crime, and I believe that the treatment that he needs, that he should be able to get. If it's not the best, I get it. I mean, it's in prison, but I believe that that's where he needs to be at this time. With that being said, it's not often that I say what I'm going to say, but I do believe in this case, as to the count 1 attempted murder, I believe that the 11 years is what he should be sentenced to. And I don't say that often to give the max, but I think this is an instance where the max is not only justified, but I think necessary to help deal with the pain and the trauma that these victims. And it wasn't just the one victim. I mean, you have victims, all of the employees who were there that day, they're all victims here. I feel like a victim just by seeing the video. I mean, that's how it has affected me. Pursuant to Reagan Totes, Mr. Halasz, based upon your conduct in the prison, if your conduct is against what the rules and regulations are, they can keep you up to an additional 5.5 years, so up to 16.5 years. If your conduct remains in line with the policies and laws of the prison, then you would be out at 11 years. Do you understand that?
Yes, sir.
Okay. Upon your release from prison, the State of Ohio Adult Parole Authority, and not this court, would have a mandatory minimum of 2 years up to a maximum of 5 years of what is called post-release control. If you fail to meet the terms and conditions of any post-release control supervision imposed upon you, then the adult parole authority can modify and/or extend your supervision and make it more restrictive. They can incarcerate you for up to half of the original sentence imposed by this court. They can charge you with a new offense called escape, another felony where you could face additional prison time. And if you commit a new crime while on post-release control, you can face the maximum penalty under the law for the new crime committed. Unless the defendant is serving a prison term that cannot be reduced under the law, defendant may be eligible to earn 1 or 5 days credit towards his sentence for each completed month during which the defendant participates in educational or other programs. In addition, the defendant may earn up to 5 days credit towards his sentence for successful completion of a second such program. This earned credit is not automatic but must be earned by the defendant. The defendant is assessed court costs in this case. However, those court costs can be paid through court community work service within the confines of the prison with the warden's approval in lieu of any cash payments. Mr. Halasz, you have the right to appeal this sentence within 30 days of the entry of the court's sentencing decision, and you have the right to have a notice of appeal timely filed on your behalf. If you're unable to pay the costs of an appeal, you have the right to an appeal without payment. If you're unable to afford counsel for an appeal, counsel will be appointed for you. If you're unable to pay the cost of documents necessary to effect that appeal, those documents will be provided to you without cost. Do you understand everything that I've said?
Yes, Your Honor, I understand.
Do you have any questions you need to ask me at this time?
No, Your Honor.
All right. Defendant is ordered to the custody of the sheriff for transfer to the appropriate correctional facility. Credit will be given for all time served in case number 691650. Anything further on behalf of the state of Ohio?
No, Your Honor.
Anything further on behalf of the defendant?
I would ask that the court consider waiving his costs. He falls under 150% of the federal poverty guidelines. The court gave him a maximum term. At a minimum, I would ask that he be allowed to have some commissary while he's there so that he can have hygiene products.
He will be able to. What I did, I ordered the court costs through court community work service. So they won't collect money. It'll just be through court community work service.
Thank you,
All right.
Judge.
Thank you very much. Mr. Halasz, good luck to you.
Thank you.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together Together we'll write a new paradigm. You paradigm, you paradigm. Whoa,